Ready, start. Section 25 within bracket F within bracket B of the Industrial Disputes Act 1947 provides that no workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until he has been paid at the time of the retrenchment compensation, which shall be equivalent to 15 days average pay for every completed year of service or any part thereof in excess of 6 months. Section 2 within bracket small o of the Act defines retrenchment as meaning the termination by the employer of the service of a workman for any reasons whatsoever otherwise than as a punishment inflicted by way of disciplinary action. Stop para. In the Hospital Mazdoor Sabhas, the Supreme Court held that the statutory requirement of the payment of compensation under Section 25 within bracket F within bracket B of the Industrial Disputes Act 1947 is a condition precedent for the retrenchment of a workman, and any retrenchment without payment at the time of the retrenchment makes the retrenchment order invalid and inoperative as the automatic extinguishment of his service consequent to the preemptive provision in his appointment order as to the temporariness and the period of his employment was covered by the words termination for any reasons whatsoever occurring in Section 2 within bracket small o of the Act in an application under Article 226 of the Constitution by the respondent claiming that by virtue of his deemed continuous service of 1 year within the meaning of Section 25B within bracket 2 of the Industrial Disputes Act. Stop para. He was entitled to be reinstated for non-compliance of Section 25A of the Act. The High Court of Madras allowing the writ made the rule nisi absolute. The writ appeal filed by the appellant respondent also failed. However, the High Court granted a certificate under Article 133 within bracket 1 within bracket C of the Constitution para, dismissing the appeals and negativing the contentions of the appellant. The court para. The grant of a constitutional passport to the Supreme Court by the High Court is not a matter of easy insouciance but anxious adherence to the dual vital requirements built into Article 133 within bracket 1 by specific amendment. A substantial question of law of general importance is a sine qua non to certify fitness for hearing by the apex court para. Nay, more, the question, however important and substantial, must be of such pervasive import and deep significance that in the High Court's judgment it imperatively needs to be settled at the national level by the highest bench. Failure here stultifies the scheme of the article of floods. This court with cases of lesser magnitude with legitimate entry para, while exercising the vital powers under Article 136 of the Supreme Court, must have due regard to the constitutional limitations of Article 133 within bracket 1 and O. Allegiance to this to those restraints save in exceptional cases 161 within bracket 3 if the workman swims into the harbor of section 25A(f) of the Industrial Disputes Act 1947. He cannot be retrenched without payment at the time of retrenchment, compensation computed as prescribed therein. Read with section 25B within bracket 2 State of Bombay and others versus Hospital Mazdoor Sabha and others within bracket SCR and 66 applied para. Statutory construction when courts consider welfare legislation with an economic justice bias cannot turn on cold print glorified as grammatical construction but on teleological purpose and protective intendment para. Section 25A, 25B and 2 within bracket small oo of the Industrial Disputes Act 1947 have a workers' mission and the input of Part 4 of the Constitution also underscores this benignant approach. While canons of traditional sanctity cannot wholly govern, courts cannot go haywire in interpreting provisions ignoring the text and context. Words of multiple import have to be winnowed judicially to suit the social philosophy of the statute. Dictionaries are not dictators of statutory construction where the benignant mood of a law and more emphatically the definition clause furnish a different denotation. Section 2 within bracket small oo is the master of the situation and the court cannot truncate its amplitude. The words for any reason whatsoever in section 2 within bracket small oo of the Industrial Disputes Act are very wide and almost admit of no exception. Stop there. Thank you.